appeal in the matter of the case on the application of Global Feedback Ltd and His Majesty's Treasury and the Secretary of State for Business and Trade.
Yes.
Good morning. I appear on behalf of the appellants, His Majesty's Treasury and the Secretary of State for Business and Trade, along with Mr. Birdley, Mr. Howell, and Mr. Riley, who I think is stuck in a protestation queue outside, but hopefully will be joining us shortly.
Right.
Miss Wakefield, Miss Love, and Mr. McCarthy appear on behalf of the claimant or respondent.
Yes.
Well, there's quite a lot to get through. I'm assuming that you've had a chance to read the parties' skeletons. You will have seen that there is a core Court of Appeal bundle, there's a supplementary Court of Appeal bundle, there's an authorities bundle, and there's something called the WWF Intervention Supplementary Bundle.
Yes.
So those are the files you should have.
We have got those files, and Sir James, can I indicate to everybody that we've read the skeletons, some of the surrounding documents, and some of the authorities. So we like to think we have a lively appreciation of the issues. So you can both take that, as it were, as read, but we'll leave you to take your own course. We noted yesterday that the time estimate is 3 hours.
It is.
And we can indicate that if it went over the 3 hours, we wouldn't be stopping you, in that we appreciate the importance of the issues. I don't want to say we've got all day, but you'll be unsurprised to learn we don't have any other appointments in our diaries. But we would be quite keen, obviously the earlier we finish, the more we can start work on the judgment. So we'll leave that to the two of you, but
yes.
that is to indicate that to you. And I think the only other thing is to say that obviously, as somebody who spends a lot of his professional life dealing with cost disputes, I can say it's very nice to have a full court room when I'm dealing with a cost dispute, because for those sitting at the back of court, I should tell you, most of the cost disputes I deal with to a very sadly empty court. So thank you very much for coming, and I hope you stay the course. Yes, Sir James.
Carries on being as entertaining as that. I'm sure the courtroom will be full to the end. On timing, my learned friend and I have had a bit of a chat. We agreed provisionally, subject to a little bit of flexibility, which we're both, I think, quite capable of adhering to, that I will go for maximum an hour and a half. We'll try to be able to finish a bit quicker than that if I can pitch in straight away to the issues, which I think I can, given the court's indication. My learned friend will then be an hour or possibly a little over. We'll probably have to come back after lunch, but we're hoping we should be able to adhere to the 3-hour time limit.
Fine. Okay. Well, we certainly anticipated you coming back, even for if it's just a bit after lunch, so that's fine.
I'm grateful. My lords, you will have seen that from the skeleton arguments, and in particular, if I can invite you just to remind yourself of our skeleton argument, core bundle, page 44, unless you have it loose, the base provisions dealing with cost capping in Aarhus Convention claims, which are broadly and subject to the issues I'm going to come to, claims to do with environmental issues. Those are set out in paragraphs 6 to 9 in particular of our skeleton argument, and I wasn't proposing to traverse those again or go through them.
Yeah.
In effect, the issue here is whether the claim is an Aarhus claim as defined in the relevant provision in the civil procedure rules, the relevant provision being Rule 46.24 brackets 2A.
Yes, and just so that everybody knows, just to claim responsibility, I drafted those rules during my time as chair of the, well, in fact, I wasn't chair, but I was on the Civil Procedure Rules Committee. I don't think anything turns on it, but people should know that there was a delay between the Aarhus Convention and the drafting of the rules. And in the end, those were the rules that were promulgated.
Yes. One sees from some of the earlier case law that they were considering a position prior to that change in the rules which you instigated. But my lord, the relevant rule now is contained in CPR 4624-2A, and that contains a specific definition of what is an Aarhus claim, Given the full court, it may be worth just briefly reading that out. A claim brought by one or more members of the public by judicial review or review under statute, which challenges the legality of any decision, act or omission of a body exercising public functions and which is within the scope of Articles 9.1, 9.2 or 9.3 of the Aarhus Convention. And so the question is whether the claim is within the scope, to use the wording in the rule and the definition of, and the relevant bit of the Aarhus Convention is Article 9.3. The interpretation of Article 9.3 of the Aarhus Convention is therefore, as it were, brought into domestic law through reference in the CPR. But the interpretation of Article 9.3 of that convention is, if I can put it this way, to be done in accordance with international law. It's an international legal provision, albeit one that is referred to in domestic law and therefore has to be interpreted by the domestic courts. There isn't an unincorporated international law angle here. But that interpretation is to be done in accordance with international law. And as my lords will all be very well aware, international law is to be interpreted in accordance with the principles set out in another international convention, this time the Vienna Convention on the Law of Treaties, which you have in your authorities bundle behind tab 22, page 485. I suspect that the provisions will be very, very familiar to my lords. So just by way of reminder, page 485, tab 22, if you would. And the relevant provisions for our purposes are on page 484, to start off with, Article 31, and you'll see halfway down the page on page 484, Section 3, Interpretation of Treaties, Article 31. Can I just refer you, by way of reminder, to 31.1. Treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. It might be thought that that is now remarkably similar to the way in which the Supreme Court have expressed the tasks that a court has to undertake in interpreting a domestic statute, in cases like Packer, our Lord Sales, in the Supreme Court recently, but there are plenty of others. But that's the prime directive, as it were. And then recourse may be had, see Article 32 over on the next page, to supplementary means of interpretation, including to travo. Those are the working documents that led to and refined the formulation of the various provisions that then become a treaty. So you can have regard to the travo to confirm the meaning resulting from Article 31 or where the meaning is otherwise ambiguous or obscure. And then Article 33.1, you will see sometimes treaties are made in different languages. Where a treaty has been authenticated in two or more languages, the text is equally authoritative in each language, and will come in due course to a debate about the English, French or Russian. Those are the three under which the Aarhus Convention is authenticated. So Aarhus has English, French and Russian. See Article 22 of the Aarhus Convention on page 515. So they're all... Article 22 of Aarhus, page 515, my lord. And the relevant three languages for present purposes are English, French and Russian. I'm not sure anyone has yet produced any decent-looking translations of all the relevant documents in Russian, but perhaps we'll get to that. So that's by way of introduction and a framing of the issue. That's the nature of the issue that the court has to grapple with. Yeah. And I wanted, if I may, to pitch straight into the argument, and we make 6 points of general approach to the issue that confronts the court, and then I'm going to come directly to the way in which the arguments against us are put, the 2018 Act, followed by public law grounds themselves being part of national law and so on. So the 6 points of general approach. The first one relates to the meaning of Article 9.3 in its proper context. And it may be worth having for this purpose the Aarhus Convention itself open. That is behind tab 24 in my Lord's bundles. If you're working electronically, it starts on page 494. And just by way of introduction, you will see, just to spin through some of the relevant provisions, you will see the recital just by the second hole punch on page 496, concern that effective judicial mechanisms should be accessible. Do you see that one? 496. That's the one that in effect forward references 9.3. Yeah. So that's the recital. You will see, maybe a provision of some interest, you will see in Article 3.5 on page 499 that it says the provisions of this convention shall not affect the right of a party to maintain or introduce measures for providing for ... jump a line, wider access to justice in environmental matters than required by this convention. So it's a saving provision that effectively acknowledges that provisions on access to justice in environmental matters have a scope that is limited by the provisions of the convention itself, and that states can go further. That's why the saving provision is in. One gets a substantially similar point out of Article 1, or at least a half of that point. If you go to Article 1 on page 497, you will see the basic objective of the treaty, and it is to contribute and so on, and then jump to the penultimate line, access to justice in environmental matters in accordance with the provisions of this convention. I'm going to come back to some of the other ones, but you'll be very well aware of the basic structure of the convention. Perhaps just a note in Article 3.8, second sentence. Perhaps read the first sentence to yourselves, and then the second sentence on page 499. This provision shall not affect the powers of national courts to award reasonable costs in judicial proceedings. So the framers of the convention are well aware that, in effect, the usual rule in most member states will be that reasonable costs of fighting and losing judicial proceedings are to be awarded. And of course, when you're dealing with claims against a public authority, the payment of those reasonable costs, and indeed the introduction of a limit on what the losing party should pay, the protective cost order regime, does involve transferring, in effect, the distributive burden from the litigator to the taxpayer. But the convention recognises that those reasonable costs are the usual rule. Then you know the basic structure. Article 4 deals specifically with access to environmental information. I'm sure all of you will have come across that provision before, and its adjunct Article 5, which is all about the collection and dissemination of environmental information. And you'll see that that includes in Article 5.3b the need to collect in certain circumstances. On page 503, Article 5.3b, text of legislation on or relating to the environment. Then there is in Article 6 a slightly different body of provisions, and they're all to do with public participation in decisions on specific activities. And again, the planners amongst you will be very familiar with that provision, I suspect.
It's got a parallel with environmental impact assessment.
There is something of a parallel.
Well, it is quite a close parallel. I mean,
yeah.
If you go to 6.6,
yes,
the various things that have to be done.
Yes.
And the other parallel, I forget where it comes now. The activities which are subject to this regime are those specified in Annex 1,
Yes.
and also other ones which have environmental effects.
My Lord, exactly so. The provision you have in mind, I think, is Article 6, 1B,
Thank you.
which might be of importance for a slightly different purpose, which I will come back to.
Yes,
My Lord exactly summarised it. Annex 1 lists various activities, and they're kind of the sort of activities one would expect.
Including intensive livestock rearing.
Yes, and energy sector and production and processing of metals, things that might be harmful perhaps, or prima facie harmful, but then it broadens it out, but it broadens it out in a way which uses deliberate language. You'll see the language. Activities not listed in Annex 1 which may have a significant effect on the environment. You see that language.
In B.
In B. And then, but my Lord is right, there are lots of parallels here, and my Lord and I have debated in the past habitats directives and all of that, and we had a case from the Supreme Court the other day about what that meant, and how that was to be applied, and what the precautionary principle meant, and all of those very familiar principles. But anyway, that's Article 6. The principal relevance for present purposes, I'll come back to, as I say, is in that first sentence of 6.1b, and in particular the use of the language have a significant effect on the environment. Article 7 then is again a public participation matter. Article 8, public participation in relation to the preparation of executive regs or generally applicable legally binding normative instruments and so on. And again, you see the same sort of language in Article 8 in the introductory wording right at the end of that first sentence, 4 lines down in Article 8 on page 507 towards the bottom. Executive regulations, rather generally applicable legally binding rules that may have a significant effect on the environment. Do you see those words at the end of that first sentence of the introductory wording to Article 8? Again, that chimes again. And then we get to the relevant provisions of Article 9 on page 508, and we come closer to the direct target of the issue that you have to consider on page 508. Article 9.1 deals with the right to information, in effect under Article 4, as you've seen. Article 9.2 then deals with decisions, acts or omissions subject to Article 6. That's the public participation regime. And Article 9.3 then requires consideration of whether there is a contravention of provisions of the state's national law relating to the environment. And those are perhaps the key words for the purpose of the present debate. And you'll see that in nature, 9.3 is about ensuring access, and then 9.4 is a substantive provision on costs not being prohibitively expensive. It applies to the procedures in Articles 9.1 and 9.3, 9.1 to 9.3 only, so not to all conceivable forms of environmental litigation in the broad sense.
So if you're, I mean, there's a tendency to run 3 and 4 together and say you've got to have JR and it's got to be made accessibly inexpensive. But in fact, they're 2 separate provisions.
They are 2 separate provisions, and 9.4 applies inter alia to 1 and 2 as well.
Yeah.
But not to everything.
But in thinking about the breadth, or however you want to describe it, of 9.3, it's dealing, as you say, not with the cost capping objective, but with
the ensuring of access.
The requirement that there should be remedies available to deal with the subject matter.
Oh, that's right too. That's the nature of it.
Which may go to the question of how wide or narrow it is.
Yes. Well, I accept that that can be relevant to that issue, but that's the correct way of looking at it. And you'll note immediately, given that the first submission is about what it means in context, that it isn't simply an open-ended provision whenever it can be said that environmentals might be said to be relevant to a decision and not to have been properly weighed or taken into account. Nor is it set on the basis of whether the act or omission, which is referred to, has or may have impacts, significant or otherwise, on the environment. So the test is not concerned simply with the potential impact of the legislation or decision on the environment. The question is whether that national law relates to the environment. And the test we submit must be whether the nature or purpose or objective of that national law in question concerns the protection or regulation of the environment.
And national law is not limited to statutory law.
It isn't limited to statutory law.
It's concerned with.
It's concerned with. But one can think of, for example, to take the legislative example, one can think of the objective purpose of various pieces of legislation, including close, as it were, to the taxation world, of levying what might be called environmental taxes, or taxes which plainly do have that purpose, such as air passenger duty, even if that isn't set out on its face. And we know from the case law it doesn't have to be set out on its face. It's common ground. There's no need for the environment to be, for example, mentioned in the title to the legislation.
It's got to relate to.
It's got to relate to.
Whatever the form or nature of the national law, it's got to relate to
Yes.
the environment.
Well, that's right. And you see that emphasised, for example, in the implementation guide. You've probably had a chance to have a look at that already, but just to go to it for this purpose to show you the relevant bit of the implementation guide, that's in tab 39, starting on page 601, and the relevant bit is in 609, towards the bottom of the page, just below the picture of someone very grandly addressing a very grand-looking body. What can be reviewed? You see the title at the bottom of page 609. Can I just invite you to read through that paragraph, which runs a little over onto the next page?
Is the illumination to be found 6 lines from the bottom somehow relates to the environment?
Well, I think that's the closest they get to it. Rather, the decisive issue is if the provision in question somehow relates. I'm not sure it takes the matter much further by putting the word somehow in front of relates.
Every time I read that word somehow, I sort of flinch.
Blank over a bit and fidget. But my lord, that is it. I mean, I was relying on it in part for that, but in part for the lack of help, as it were, but in part for the decisive issue is if the provision in question, so it's focusing on the national law, the provision in question somehow relates to the environment, plus also acts and omissions that may contravene provisions on, among other things, city planning, environmental taxes. So again, the flavour of it is you look at the law in question that is, and ask the question, is that law designed to protect the environment? That's why it refers to environmental taxes, not saying any old law that has an impact, significant or otherwise, to use that language, on the environment. This is about the focus on the nature of the law that you're dealing with. So that's really what I take.
Sorry, designed to protect the environment. Where do we get that?
It's not there.
It's not there, no, but it's the reference to environmental taxes that I'm referring to.
Yes.
And so it doesn't just say taxes that might have an effect on the environment. This is about so taxes that are of a particular nature. So I rely on this in particular part for the need to focus on the particular nature of the national law in question, whether or not it is.
But that submission is strong support for bringing into 9.3 something which isn't expressly relating to the environment. That it's not. The underlying purpose of the provision is not stated to be something which is determinative of whether it falls within 9.3 or not.
Well, I'm not sure one would go as far as that. You don't need to find that purpose expressed in the title.
Correct.
It doesn't have to be expressed in there. But the question is, what is the nature? When I made the submission, it was the nature /object/purpose of the law in question. Is it part of the panoply that's designed to protect us? So I'm drawing a contrast between that type of law.
But what if you have something which isn't designed, so it's not the primary purpose, but can be seen to relate to the environment?
Well, my lord, then you have questions of relative degree, and then you have to make a judgment.
Well, then, yeah, we've got a Court of Appeal decision on that.
Yeah, sometimes it is, and sometimes it isn't. We'll come to then in due course, which is all about planning and policy.
What I'm niggling away at is relating to the environment is not limited to things with the purpose of which is to relate to the environment.
Well, my lord, again, I don't want to dance on the head of a pin about precise words.
Well, I think this could be said this appeal is about dancing on the head of a pin.
All right, well, let's dance on the head of the pin then. I used the phrase nature, or purpose or objective, because the purpose and objective will inform the nature. And what I'm really driving at the core of my submissions, and I'll come to make them in due course, is the distinction between the things that are set up in national law that are in nature the protection for the environment, paradigmatically legislation. That's why they use environmental taxes in the implementation guide, not just taxes, versus any general law that might, in a particular circumstance, have an impact.
But what this may be influenced by is the meaning of in relation to. That is something of a chameleon expression. The strength of the link that it's talking about can vary from one statute to another. And the dictionary says that it's equivalent to, or can be equivalent to, in connection with. A similar connector, where the case law says it can either be a strong connection or a weak connection according to context. But you're going for quite a requirement of a strong connection, really meaning having to do with.
Well, I'm going for a connection. I'm not going for no connection. In other words, entirely general.
Some connection.
Some connection, my lord. Yeah, I mean, I can.
Yes,
of course.
When you say, is it designed or is the nature, purpose, or object concerned with the environment, that sounds like quite a strong connection, quite a strong link, having to do with.
Yes, well, my lord, I don't apologise for that. I mean, one can argue about the adjectives, and of course I recognise that relating to is, in our parlance, ordinarily a broad concept, and so is in connection with. And I, of course, also recognise that we're dealing with an international convention. See Lord Justice Sullivan in Venn, which I'd entirely forgotten that I'd argued until I read it last night. But it's a broad, purposive thing and has to be interpreted as such. But nevertheless, the question that I raise in the appeal is whether or not it is entirely general. Is it? We will come to it in due course, but is it, as WWF contend, merely some form of impact of the decision, in effect, on the environment, which can be controlled by public law? But if so, that would enormously open the door, and there are purposive difficulties with that, particularly given the recognitions that we've already seen in this convention. So my case is ultimately that the convention is designed to provide a special rule, albeit controlled by the concept of relating to the environment, but it has to be the national law which relates to the environment. It isn't just the decision has an impact or someone's chosen to take it into account. You have to look at the national law, and we'll come to the case law, which at least suggests that it is relevant when considering relating to look at the object and purpose of the law in question. But I deliberately put it on the basis of looking at the nature of the law. So again, one can take a variety of things helpful and rather less helpful from this passage in the implementation guide, but for present purposes and for the purpose of my case, I take in particular the focus on the provision in question, directing us to the national law, rather than to mere impacts of decisions or impacts under a particular scheme which has nothing to do with the environment, as it were, on its face. And I take as having some significance attached to it the reference that when they're giving examples, they refer to things like environmental taxes, rather than pure general taxation, which of course might affect economic activities of individuals who are subject to those taxes, and that might make them more or less keen to build a plant which has super efficient emissions controls on it or whatever. But they refer to environmental taxes, and I gave you the example of air passenger duty. So that's the first submission, the wording of the, hopefully consistently and in harmony with the Article 31 direction in the Vienna Convention on the Law of Treaties on the nature of the wording. Second submission, I've already teed up to some extent, but I make it anyway so you see the sequence. The drafters of the Aarhus Convention could have made provision by reference to a broader test, simply focusing on the environmental impact of a decision or of a decision / omission not being properly considered, if that indeed had been the intention. And they didn't do so. They didn't set up 9.3 in that way. For example, it could have said access must be afforded to challenge on any basis under national law, and that would be the only basis in effect on which you'd end up in a challenge, access to challenge on any basis under national law, acts or omissions which would or might have a significant effect on the environment. That would have been a perfectly coherent bit of drafting if they wanted to do it that way. We know from 5.3b that the obligation is to make available in electronic databases, I took you to it earlier, the text of legislation on or relating to the environment. But we see the concept of relating to the environment in Article 7 as well. But we also see, in particular, note this, the Article 6.1b provision that we looked at earlier on page 505, dealing with the public participation requirement and covering proposed activities not listed in Annex 1, which may have a significant effect on the environment. There's the wording they could have used. Shows that the drafters could have devised a test by reference to potential environmental impact, whether of generally expressed law or of decisions, if they wanted to. And they didn't do that. And you have a similar set of provisions, a similar bit of wording. You can see my lord is itching. Can I just make the final point and then leave it open? Article 8, similar provision, executive regulations and so on, legally binding rules that may have a significant effect on the environment.
The kernel of that submission is not so much that they could have said something different, but that within the convention itself, specific language is used to denote specific provisions. And that is what is missing in Article 9.3.
Yes, a structure in that way, because you'll appreciate the nature of the argument that is being run against me in its most extreme form by WWF, but also to some extent by the respondents. It says with general legislation, you're required to take it into account. That's a public law duty. If it's an environmental thing, we'll all be very familiar with this from our Mozambique liquid natural gas plant case, but you take it into account, there we are. That's all about impact on the environment. And you can say in broad purposive terms, here's the thing to do with the environment. It's all to do with the environment. It's got that environmental feel, that's wizard. But the problem with that submission is that under this convention, it specifically sets out that it's providing for specific nominated and defined obligations, including 9.3. It permits the parties to go further, and the protections that are to be provided under this convention are to be provided in accordance with the terms of the convention. And you can go further, and you can go further in one of the ways under this convention by going beyond Annex 1 in the context of, say, Article 6, if something would have significant effects. If they wanted to draft in the four corners of this convention, if they wanted to draft 9.3 so as to catch access to justice as an obligation in circumstances where either the law generally expressed or a decision or an act or omission did have a significant effect on the environment, and they could have done that. Indeed, it might be thought that would be super consistent with this big, broad environmental purpose that it's designed to serve. But they didn't do that. They
in this context, could I ask about Article 9.2? Authorities bundle, page 508. because you've rightly drawn a link between this and Article 6, the EIA type provision, but it reads on. It's just below subparagraph B, subject to the provisions of Article 6, and then there's a parenthetical where so provided for under national law without prejudice to paragraph 3 below, of other relevant provisions of this convention. So it goes beyond Article 6, subject to what appears between the commas. Is that the right way to read it?
Well, I suspect one could probably...
Not surplusage.
No, it's not surplusage, but you...
Quite carefully drafted.
It is quite carefully drafted, but you might have... Well, I'm not sure that does it add much to Article 6?
For example, to illustrate, there are two questions underlying this point. You took us helpfully to Article 7 a moment ago.
Yes.
Which is the equivalent of strategic environmental assessment for plans and programmes.
Yeah.
Now, that provision doesn't have its equivalent in Article 9, but it might be perhaps covered by other relevant provisions of this convention, subject to being a matter provided for under national law.
My lord, it might be.
Yes. My second question then is, why did the draftsman put in the words "and without prejudice to paragraph 3 below"? What's that doing? In terms of the relationship.
It may be that it's distinguishing between the review procedure that is required under 9(2) and the perhaps rather more broadly expressed access to administrative or judicial procedures. Is that it? It may be saying that these review procedures are not designed to cut down the reach of that.
The breadth of 9(3.
Yes.
Which is primarily concerned to ensure remedies are available.
Primarily concerned to ensure remedies, but also access to administrative and judicial procedures, which might be rather different to review.
Yeah.
So it's effectively saying, I think, isn't it? It's effectively saying, well, you can't use this one to say that if you're within 9(2 prima facie, you can't, that broader guarantee, if it exists, doesn't apply. That's how I've read it, but I may be.
Thank you.
Well, I don't want to lose in the detail of these questions and answers the broad submission which is made, which is here is a convention which, as you say rightly, is carefully drafted, sets out some specified rights, recognises that the parties can go further, recognises indeed that reasonable cost is the ordinary way of going about things, and therefore will have understood that in public authority, legal aid type context, that's a burden that is transferred to the taxpayer. It's only giving specific formulated rights. They could have set it up 9(3) very differently because they've got the language that would have enabled them to do that in the very provisions that we've looked at, including 6(1)(b) and Article 8, and they chose not to do it that way. That's the second submission. The third submission is to do with purposive considerations. And of course, I start by acknowledging that the purpose of Aarhus is protective of the environment, and that's a very important purpose, and protective of enabling public participation in decision-making and access to justice. But for all the reasons I've given, it is not unlimited. The controls and the limits of the rights and obligations that are conferred are built into and acknowledged within Aarhus itself. See Article 3(5) amongst others, and see the fact that it deliberately used the wording that it did. It is already, that's 9(3), is already very broad on our interpretation. The breadth is acknowledged by the various principles we've seen set out in the implementation guide, and I'll come to the case law next in the fourth submission, but it's already very broad on that basis. You don't have to refer to something in the wording of the legislation itself if you're looking at that, or in the title. Doesn't even have to refer to environmental law. It's already very broad. The real question is whether it is virtually unlimited, because whenever someone can make an arguable case that an environmental matter is relevant to the Decision Act or omission and makes that subject to a public law challenge. That's a very easy thing to do, as we know, under domestic public law. You just bring it in. That's effectively why I'm here, because there is genuine concern about the breadth. That's genuine concern about the breadth of it.
But it is, but it's got two limitations. One is costs, consequences, but the other is we have a filter system. So that one of the answers to your submissions is, because there's a sort of nuance in what you've just said, that anybody can just turn up with a case however rubbish it may be.
No, I certainly don't say that. It has to be arguable.
They don't get permission.
They don't get permission, of course.
And if it's arguable, the moral objection, or what you're trying to create as an almost moral objection, doesn't hold much water.
My lord, I don't agree with that proposition, for obvious reasons. It is not that difficult to surmount permission in this way, and my lord will be, again, very well aware, take the Mozambique example, very well aware that there's a great big raging debate about the extent to which one takes into account international law and domestic law. What happens if the decision maker chooses to take it into account?
Well,
at least on one view, that brings it into domestic law.
I've been biting my tongue on a question because I knew we'd get here.
Well, here we are.
But on 9.3,
yes.
Can you just articulate for me so I can understand it clearly? What is the position where a statutory provision, which isn't self-evidently itself relating to the environment,
yeah,
requires consideration of an international obligation which is not otherwise incorporated into English law, but which clearly does relate to the environment?
Yeah, well, my lord, my submission is that you are, in that situation, not within Article 9.3 for reasons I will develop. That's a clear enough answer at this stage.
That's clear enough at the moment.
Of course, that's going to be the issue under Section 28.
Well, exactly. I mean, and it's also the possible distinction between this and Mozambique. Because
well, yes, it is. Although, of course, the reason I was going to Mozambique was not so much specifically for this purpose, because you weren't in that territory where there's a statutory provision which arguably required amongst all the other international law that exists and so on. But it does illustrate the breadth. And the point I'm on at the moment is the purposive concern that says you open the door incredibly broadly if you go down this route, because, of course, JR is controlled by arguability, although there may be questions about whether or not this protection would apply even if you turn it down.
Okay, I'll leave it safe to say this, that there is the added complexity, which we have both in Mozambique and this case, which is where the decision maker decides to take into account something which they may not otherwise be obliged to. Because on your argument, Section 28(1) did not oblige them to take into account the. But they
did in fact do so.
But they did in fact do so. So we've got to cater for that.
My lord, you have, and that, as I respectfully submit, brings the purposive point very sharply into focus. Because, as you're aware, in relation to all of those arguments about whether international law has come in through the voluntary looking at it of the decision maker, and there's a whole raft of complication in relation to that. But at least as one of the things that the courts have been deeply concerned about, including Lord Bingham in Cornerhouse, as you will recall, is the perverse incentive that would be created if you created a situation under domestic public law in which the decision maker was in a better position if it said, well, I can see that there's an international law provision over there, and I'm deliberately not going to look at it. That's what was concerning Lord Bingham in Cornerhouse and has concerned a myriad of courts since then. And the problem with that is that if responsibly, and it might be thought a fortiori responsibly under the present government with its emphasis on rule of law and international law, if responsibly ministers look at international law to inform their decision making, at least on one view of it, there may be a debate about whether it's still non-justiciable and how far that extends, but at least on one view of it, see Friends of the Earth in our case, in that Mozambique case in the Court of Appeal, the standard is one of tenability, You have an argument about what that means. You can have an argument about, even assuming it means A, B, and C, whether we apply that test correctly to the facts when considering it, even though it's unincorporated into international law. There are plenty of ways in which, and we see it very, very frequently across the raft of litigation, lots of which has some echo, unsurprisingly, into environmental law. It's no accident that Friends of the Earth are the claimant in most of these cases, or lots of them. You can bring in all those international standards to try and control what would otherwise be general decision-making. And you can do that particularly in circumstances in which the minister responsibly, albeit not subject to a domestic legal obligation, takes into account voluntarily the international legal environmental standard. So that's why there is this purposive concern, because it cuts against the grain of that in those cases, that's enough to bring it within 9.3 and thereby, in effect, to transfer the cost burden that the unsuccessful claimant would otherwise bear to the taxpayer.
But the transfer of the cost burden, as you said already, comes from Article 9.4.
It does.
So the relevant question under Article 9.3, when we're testing the strength of the connection which is necessary, is would a country be in breach of Article 9.3 if it didn't provide a remedy to deal with that situation?
My lord, yes, but my submission is that you've got, of course that's right.
Yes.
And we discussed the distinction, the dichotomy between 9.3 and 9.4 before, and I wasn't disagreeing in any shape or form with my lord on the structure of it. But when you're considering 9.3 and 9.4 together, and they do sit together at least for cost purposes, you are entitled, in my submission, to take into account the purposive considerations.
Well, 4, of course, we shouldn't forget, also applies to 9.1 and 9.2.
It does.
I mean, it's not intimately linked just to 9.3.
It isn't, but it is linked to 9.3 because it provides, as it were, the substantive cost rule alongside the remedy that 9.3 is directly concerned with. So for the purpose of this debate, it isn't an illegitimate consideration to view them together.
I mean, we're in a jurisdiction where we're used to all these remedies being available and plentiful, but this is an international treaty to be interpreted in accordance with the Vienna Convention, and perhaps the focus of 9.3 has got to be, well, what would be the answer if a country did not provide a remedy?
My lord, yes, and my answer would be the same.
But it has to be.
Yeah, but my answer would be the same. But you can't. My point is, you can't ignore, as part of that, of course, you answer by way of testing it the remedy question too. But when you're considering the cost consequences, you read 9.3 and 9.4 together because that's what creates the cost consequence. And the same point applies. You're providing remedies and you're providing this cost protection in the circumstances set out in the Convention. The question is, does it extend as broadly as is contended against me? And the reason I bring that in, when we bring it in as a standard position under domestic legal argument, but in my submission, it plays in exactly the same way, despite it being an international convention, because countries that sign up to these conventions are assiduous themselves to protect and to bear in mind the limits of what they're agreeing to on the international plane. So if there is a situation in which it's virtually unlimited, for the sake of argument, in relation to cost protection, then that is a real concern, and would have been of real concern to the drafters of the convention. That's the third submission, anyway. Yeah. The fourth submission is to focus a little bit on the case law, and I wanted to look at essentially 3 cases will probably be enough. The first of them is Venn.
Yes.
And Venn is behind tab 10, starting on page 114, a decision of the Court of Appeal. And the relevant passage of Venn for present purposes starts on page 118. At paragraph 10, you see the title above paragraph 10. That runs to the end of paragraph 18 on page 120. Those are the key bits. And within that section, it's perhaps worth just casting an eye down 10 if you would. Sets the background to what the court was actually considering. and 11, namely what we had accepted in that case. You'll see the nature of the argument that was advanced at paragraph 14, and in effect its narrowness. It was in effect an argument that sought to distinguish between law as in legislation and law as in policy made under the legislation. That was in effect the rejected argument in that case. You'll see at paragraph 15 the death knell for the submission in the first line, the description of the submission as ingenious, which is normally the death knell for an argument. At least he was rather more polite than Lord Wilson, who once rejected an argument of mine in terms that said it was misconceived even at the high level of pedantry at which it was pitched. But at least Lord Sullivan...
that is rude.
At least Lord Justice Sullivan was polite enough to say ingenious.
I may want to use that.
Ingenious would be rather better if my lord were...
We'll leave it at ingenious.
If I could negotiate ingenious with my lord, we'd all be very happy. But 15, you'll see, is the court's reasoning more seriously. And so can I just invite you to cast an eye down 15, 16 and 17?
Yeah, shall we read that?
Yes, could I invite you to do that?
Yeah.
Well, you'll see that the essence of the reasoning is that in the context of the planning acts, those planning acts, see para 15, were the mechanism by which Parliament had, as it was put, chosen to implement much of the UK's environmental protection through that system. So you've got the system of planning, which is the legal structure of which is in essence designed as a national environmental law, if you will. And what is being done is simply to reject the submission that in that context you can draw a sharp distinction between the provision of the law, section 70 sub 2 requires it to be made and taken into account, on the one hand, and policy on the other.
Well, although it's small p policy, because it's planning, actually just about every planning case turns on the
policy
NPPF.
itself.
So it's a policy as distinct from simply government small p policy. It's policy in the context, you say, of planning.
I do.
And therefore the NPPF and local authority if they have a local plan or a local policy.
So it's both the context of the law.
Yeah.
Planning is, as it were, the prime mechanism for dealing with the state of the land and all of that. And it's also the fact that in that context, as my lord rightly puts it, policy with a big P plays a very significant part, because most of that system of protection is provided by that combination.
One is, taking the second one first, in the context of planning law, the way it's done is that the statute incorporates the policy as part of the environmental law. But the second part, which I think you emphasise, is that the system of planning was designed to implement the UK's environmental law relating to planning, and that's how it does it.
It's got to be both of those. It's both of those stages
that
to get it
resonates
in.
with your purposive.
Yes, it's both of those stages. My lord is right to break it down into those two, but it's both of those things. That's the answer to Van. We respectfully submit. So that. Oh, sorry. No.
I was thinking. I'm sorry.
No, don't worry.
My lips were moving. It was simply because I was thinking, and you're lucky I wasn't thinking out loud.
I'm sorry, I didn't want to interrupt.
No. I had nothing further to
No, thank you.
I'm just
very well. Client Earth, then, if I may. That's at tab 19 on page 393.
Just going back before we leave, though, Ben,
yeah.
it is accepting in 17 that the law, the legal element, doesn't have to relate directly to the environment. That seems to have been, perhaps, because of section 17, subsection 2, which required the policy to be taken into account.
Yes, my lord, I think
maybe you have to read the two together.
I think that's the connection, and it's in the context of planning. It's both of the stages of my Lord Justice Stuart-Smith's.
So it's policy within that
statutory framework. Exactly.
But I think one of the arguments you were advancing in that case was that there was no contravention of the legal element, i.e. section 70, subsection 2.
Yeah, and they were not having that either.
No.
But they were not having it in the context of planning, which is set up in that way. It's designed to protect the environment in that way, and in which policy with a capital P, as my Lord Justice Coulson put it, is centre stage, as it were.
So you can have, if you have, forget planning, if you have a statute which requires, for example, policy to be taken into account, which has the effect of protecting the environment, that would accord with the reasoning in Venn.
Well, you could have that. My respectful submission is it becomes a bit more difficult if you say, forget about planning as the introduction to that question, because it may rather depend on where you are.
Well, I'll give you an example. There's quite a few cases involving Transport Action Network. You've probably been involved in some of them. But there is the Infrastructure Act of 2015, which gives the Secretary of State for Transport power to adopt a road investment strategy. It's basically about investment and funding for the strategic highway network. But Section 3 says that in adopting such a strategy, he must have regard to the effect of the strategy on the environment.
Yeah.
Now, if the statute says that, wouldn't that fall within
well, my Lord,
Article 9.3?
My Lord, it may do. And I don't want to get into a debate around legislative techniques expressed in the general as opposed to expressed in the specific.
It's an illustration as to whether Venn is confined to the planning system.
And I'm accepting that it may not be.
Yeah.
It may not be, but it's an important part of Venn itself that it was to do with.
Think about that in order to decide which side of the line this case falls.
My Lord, yes, and that will require you to look at the legislative scheme under which it is made, the nature of the provision.
Why shouldn't it be enough that you have a statutory framework which requires policy to be taken into account, which protects the environment? Why shouldn't that suffice?
Well, my Lord, in some circumstances it may.
Say that, but why shouldn't it in all circumstances?
Because that would be to create too broad an exception, I respectfully submit, too broad a situation under 9.3, where the focus is on the national law in question and whether or not it is designed in that way to protect the environment. Now, I can see a perfectly decent set of arguments that say, well, in certain circumstances, if you're dealing with something like your transport infrastructure, that is remarkably close to planning, the transport...
Except that's a funding statute. It's nothing actually to do with the decisions as to whether any particular project should go ahead. It's all to do with having a strategy which decides how much public money is going to be spent on roads and where.
My Lord, yes, but you can still have the argument about whether or not, despite that fact, it is close enough to bring it within the concepts that 9.3 is dealing with. So I'm not shutting the door to the possibility that even in the context of funding decisions, as opposed to correct or specific decisions about implementing infrastructure, in the context of planning decisions, it may well be that the example you give me does fall within. But my submission is you can't reason from that to a position in which whenever you take into account as relevant, whether pursuant to a statutory requirement generally expressed or whether pursuant to a public law obligation of the kind I was discussing with Lord Justice Stuart-Smith, as long only as it's got some kind of impact on the environment or the policies.
No, but I'm asking about a statute which requires the environmental effect to be taken into.
My lord, you are, and I hope.
And I'm just trying to work out if there are some statutes which have such a requirement that they don't fall within Article 9.3, and there are some which do. How do you draw the distinction? How would the court do that?
Well, my lord, you'd have to look at the nature of the underlying statute in question, the purpose for which it was requiring the thing to be taken into account, and so on.
So you're almost looking at the primary purpose of the statute, and if you say it's to fund the road system, that doesn't count, or if it's to levy taxes, it doesn't count, if that's the primary purpose.
My lord, you look at all of those things. As I say, of course I understand why my lord is asking me the question. You've got to probe the principle. How far does it go?
Yes.
If it says take it into account directly, then one can see a powerful prima facie case, at least, for that forming part of the national law designed to protect, because that's the thing that is required to be taken into account. But one needs to be a bit careful with that, because it does have the potential to open the door very, very broadly. And then one starts getting into questions as to whether or not, if a statute just generally says, like Section 28 does, here we are, take into account international law generally, whatever that might mean. If you take it into account, is that enough? If it's as long as only as the thing that you've taken into account is a thing that is related broadly to the environment. And if that is right, if that is the position, this is the logic of my learned friend's argument. Why isn't the same position under public law, where you take it into account voluntarily, the Mozambique sort of situation? So although I know my lord was asking the question directly, because it's at the sharp end of the argument, as it were, but you ask the question directly, what happens if the statute says it deliberately? My answer is it does depend on the underlying purpose of the legislative scheme itself, the directness with which Parliament has dragged in the environmental considerations or otherwise, and whether or not one can truly say that this is part of the national law relating to the environment for the purpose of Article 9.3.
Thank you.
Claimant Earth is obviously a case that to some extent turns on its own facts. It's in behind tab 19. I was going to it, if it was some temerity, because it was Mrs. Justice Lang, and she was the judge at first instance here, as you know, and so obviously took the view that this was a rather different sort of case. But it is at least an example of a case in which you consider a provision of national law, in that case, Section 87A of Financial Services Markets Act 2000 and all the prospectus regulation. And there is then, as it were, dragged in at the later stage, or potentially dragged in at a later stage, something which looks a bit environmental, if I can put it that way, without trivialising the issues. The reasoning in question is really contained in paragraphs 41 to the end of 43. On page 402.
Just as a matter of interest, does the respondent accept that this is correctly decided? We haven't been asked to, you haven't asked us to overrule it.
We haven't asked the court to overrule it, but we do say it turns on its facts.
You say it's wrong? I'll ask you in an hour or so.
Do ask me when I'm on my feet later. At the moment, we haven't asked the court to overrule it, but we do say in particular the judge's treatment of Austin perhaps is something to be desired. I can develop that when I get on my feet later.
And we have to remember, don't we, that I mean, in Claimant Earth, there were leading counsel for both sides and it was a renewed application. But both sides in one of these cases wants an early decision on Aarhus, don't they? Because the claimants need to know that they've got that protection. The respondents need to know if the claimants have got that protection. So it's something that is decided, can be decided on paper by the judge first time round. And even if there's a renewed application and there's an oral hearing, that's the focus of that is the permission. But maybe Aarhus as an attachment to that,
but it won't always be thus.
No. So we need to bear in mind, don't we, that the judges deciding this have got a relatively small window and maybe access to a relatively limited amount of information.
My lord, you do, and it's going to be a part of my fifth submission, which is that judges are going to have to look at this at an early stage of the proceedings.
Yeah, absolutely.
On the basis of arguability, and so you need some clarity and some easy look, there's the law, what does it do?
Yes.
But I go to client earth for obvious reasons. Here's a provision which the judge accepts, is on its face not designed to form part of, doesn't form part of the UK's environmental law, first sentence of paragraph 41. But its purpose and effect is as described in the pre-penultimate sentence of paragraph 43, the line beginning flooding. The purpose and effect of the prospectus regulation 87A of FSMA is, however, to ensure that investors are properly informed about risks which are financially material to the issuance of securities, not to protect the environment in any way. Any connection with the environment, the purpose of Aarhus is incidental and remote. So again, I know it doesn't address the rigour of my Lord or Justice Holgate's questions to me by reference to what do judges decide this, for me to say, well, it's a relative question and degrees of connection matter, looking at the various things that we discussed earlier. But this is at least an example of one of those cases on the other side of the line, where the legislation itself did not form part of, it was not in nature, did not have as its object and purpose, being part of the panoply of national legal protection for the environment. So that's client earth.
Yeah, I mean...
The different facts, of course.
It seems very different. The point you get from Brown Bear, I think the only point I got from Brown Bear, paragraph 46, is 9.3 is concerned with environmental protection. So one way of testing client earth is to ask the question, well, what did the claimant say ought to be provided further by way of environmental information? Well, they weren't asking for an environmental assessment, for example.
Well, you get that from paragraph 16 on the top of page 398.
Well, I also got it from 27, but let's look at 16, because basically it was all about protecting investors, not protecting the environment. It was about making sure investors had enough information, as you see from 27, about the effect of climate change on the future of the business,
yeah,
and what it might do for share value, for example.
But you get the same point rather more directly from paragraph 16, as you see under grounds 1 and 2. Prospectus does not disclose adequately or at all ethical assessment of its climate-related financial risks.
Yes.
By reference to the probability of the current expected environment, climate change, Paris Agreement, net zero commitment.
And that was the lens, that was the perspective in the case. It had nothing to do with protecting the environment.
Well, my lord, you can have an argument about that. It did have something at least to do with the protection of the environment, because one could mount an argument that said that is one of, albeit indirectly as it were, that's one of the ways requiring those sort of things to be concerned when you're raising money in the city is one of the ways in which national law protects it. And if you've got that obligation in there, that's a pretty salutary piece of control to protect the environment, because those who are seeking to raise money through prospectuses or money to buy shares in companies that are going to do things have got to disclose these climate things. One can see that being argued to be really rather in practical terms an important way of looking at this. I mean, I don't want to overstate it, because the judge reached, we respectfully submit, no doubt, the correct conclusion on the facts, which was that it wasn't close enough. But you can't dismiss this case on the basis it's fundamentally different because nothing had anything to do with the environment. The whole point of this was to say, you, the raiser of money for the purpose of buying the shares or whatever the prospectus was designed to do, have got to disclose environmental risks. So we do submit.
But only insofar as it's relevant to assessing the risk of the company.
Perfectly happy to accept that proposition and by way of control. But for my submission as a result is that doesn't undermine the potential impact on protection of the environment were one to have a requirement of that kind built into the law.
So your submission is that, picking up my Lord Justice Coulson's point, for a judge looking at it at the beginning of the outset, who's going to have to look at what's alleged, what is alleged includes an impact on the environment.
It does. But they've still got to make a decision.
But it's not sufficiently strong
Exactly.
on the findings here because it's not the purpose of this legislation.
Not for the purpose of this legislation. But again, they don't. The judge's reasoning with respect to her does not simply say 87A of FISMA is about something else, full stop. She does look at the degrees of connection and so on, and then reaches a relative conclusion, in effect summarised in the final line of paragraph 43.
Yeah.
Too incidental and remote. Now, of course, that does require a judge to do more than simply look at the law itself, so it's not super simple, but it is at least dictating that analysis for the judge to undertake.
But it's looking at the effect on the environment insofar as it affects the valuation of the company's business, or if you prefer, just the business.
But my lord, it is doing that. That's the nature of the prospectus. The prospectus is raising money for private purposes.
Yeah, I understand that. But it's an important qualification. It's not requiring a general assessment of the impact of for example, the company may be running a certain business which has an effect on the environment, but an environmental specialist would want to see that in the context of all the other contributors.
My lord, there are those distinctions, but my submission is that even though it relates to private matters, if I can put it that way, because it's to do with prospectuses, so it's all about the company world, as it were, even though that's the position, it's still, as it were, of interest that the grounds are as mounted, because they are to say that these matters are relevant to institutional investors. Unsurprisingly, in the modern world, they're relevant to institutional investors who will no doubt have their own, my lord, be very familiar with it, their own internal corporate procedures about making sure that when they invest in sensible ways in companies that don't trash the environment and all of that, the social responsibility agendas that many big corporations have. And it might be thought in practical terms, when one introduces this sort of qualification or obligation into that private world, that is of some significance. I say the judge decided it wasn't enough.
I'm just going back to Article 16.1, it's a paragraph 11 of the judgment, which defines what the risk factors are. They're limited to risks specific to the issue and material for taking an informed investment decision.
Yeah. Well, yes, I don't want to have a heated agreement about that. I entirely accept that. My point follows from that, however, which is that it still can be treated in the way that I've indicated as important, as it were, at least on one view of it, as creating a significant environmental impact. But as I say, the judge decided not enough. Can I go from domestic law to Europe?
Yeah.
And the Deutsche case. Deutsche Umweltlife. Tab 21, page 437. And the paragraphs I want for present purposes are 51. 51 to 52 first, on page 470 at the bottom. In the judgment, you've got in the usual way the Advocate General's opinion first.
Yeah.
And then the judgment of the court, para 51.
Forgive me, can you just give me the page reference in the authorities bundle?
Yes, 470, my lord, I think it should be. Tab 21.
Yeah.
Yeah.
You should have 51 at the bottom of page 470.
It should be borne in mind.
Yeah, I'm going to
Yeah.
do it electronically because my bundle was...
It's fallen apart. 470 is the page.
Thank you.
And really it's picking it up at 52. And this is for the purpose of emphasising the way in which the analysis went. The finding that Reg 715, 2007, in particular Article 5.2, had such an environmental objective and therefore forms part of the law relating to the Convention within the meaning of Article 9.3 of the Convention is not, and so on, in any way undermined by. So they're treating the environmental objective of the relevant law there as a provision of EU law, but it matters not for present purposes. It had the environmental objective and therefore formed part of the law relating to. And you see the same point being picked up in paragraph 54. That finding is supported first by Reg 1367 of 2006, whose objective, underlined in accordance with Article 11D thereof, is to contribute to the implementation of the obligations arising under Aarhus by laying down rules and so on, granting access. So they're focusing on the objective of the law in question. And then the same analysis, the same sort of reasoning you see in 57. This was all about emission control systems. Picking it up about 3 lines down, effectiveness of the emission control systems must be prohibited, in no way alters the fact that the provision seeks, by way of such prohibition, precisely to limit emissions of gaseous pollutants and thus to contribute to the environmental protection objective pursued by that regulation. So you get the same features in domestic and in EU law, focusing on the objective, purpose, nature, however you want to put it, of the provision. To come to our domestic law as part of the 5th submission, if I may, focus on the nature, object and purpose of the law in question, being on the protection of the environment. That focus is also supported, we submit, by the need to apply Articles 9, 3 and 4 at the outset of proceedings. Back to the point my Lord Justice Coulson was asking me about. Article 9.4 is of course not prescriptive, but plainly one of the ways in which it would be likely to be implemented, and that's what's been done in part 46 of the CPR, section 9. The court decides at the outset of proceedings if a claim falls within 9.1 to 9.3 in order that it can apply 9.4. That is why, in accordance with our domestic case law, I think the relevant authority is McMahon, Mr. Justice Ousley, paragraph 239, don't need you to turn it up, authorities, tab 11, page 189. What 9.3 embraces on that authority alleged contraventions of national law as well as actual contraventions. But the court has to form a view about the characterisation of the claim, where there may be contested allegations of fact and law that it won't be able to determine at that stage.
So you accept what he said in that paragraph?
My Lord, I do.
Thank you.
Paragraph 240, did you say?
239.
239, thank you.
So it's got to be applied objectively at the outset of proceedings. It doesn't therefore require, and probably couldn't have too elaborate an analysis. It requires the court to consider, and it supports our submission that the court needs to focus on, the nature of the provisions said to be contravened and whether the provisions themselves relate to the environment. That's the punchline, as it were. Whether they have, in their broad sense, the object or purpose of protecting or regulating the environment. And it's got to decide that issue for itself at the earliest opportunity. Can I turn briefly to the Travo? That's the short 5th submission. The 6th submission relates to the Travo. And again, I can spin through these relatively quickly without getting too sucked into the linguistic differences that there might be. Tab 26 in the authorities bundle is the beginning of
Just forgive me for being slow, but going to the Deutsche case, the issue there was, the relevant issue was one of standing. That's why they were looking at Article 9.3.
Yes. think that's right.
So it was access to a remedy.
It was access to a remedy, but they were considering what Article 9.3 and those words required, and they focused on the objective.
Yes, well, the objective is pretty clear. These were devices to deal with
Carbon emissions from cars.
Emissions from cars.
They were.
Devices designed to defeat the control.
Well, that might be so, but they were looking at the relevant provisions of the law, and there was obviously quite a complex argument about that.
Sorry to go back to that.
No, not at all. I should have drawn that to your attention. Travo, tab 26. Just to show you how 9.3 came about. Page 526 behind.
I understand that that's the aim of this part of the submissions. Is there a, before we get there, is there a punchline? I mean, I only say that because I'm always nervous about Travos and anything that's not the actual document itself. I know there's masses of authority that say how helpful these things are. I've never known a case turn on them, but maybe one day before I retire I will get a case that turns on them. But what do you say we're going to get from looking at this stuff?
Well, my lord, that the focus should be on the provisions of national law. In a nutshell.
No,
I can take it very, very
no,
quickly.
that's fine. I always liked.
Know where you're going before we go there, but
Well,
I can do
yes.
it very swiftly because
I'm not as quick as my lords, you see, so I need help. Okay, so
526.
We're in tab 26.
Tab 26, 526. You see the date between the first hole punches. First session, Geneva, 19 June 1996, and then the relevant provision at this stage is Article 6 on page 527. In particular, can I invite you to note 6.1, each party shall ensure, I'm dropping down 2 or 3 lines, each party shall ensure effective access for the public to judicial and quasi-judicial proceedings relating to matters covered by the provisions of this convention, as well as matters relating to the protection of the environment, including the provisions of adequate remedies. Then 529 in the next tab, I think 27, this is the second session. And you'll see that at this stage, having had that initial wording, they consider the draft wording that we just looked at. See paragraph 11 at the bottom of page 529. And you'll see their conclusions on that. You see the reference to Annex 1 below. Annex 1 starts on page 530, as you see. And in the context of Article 6, final sentence of the introductory wording, it was recognised that this issue would require careful wording.
So we can assume that the final result is the product of careful wording.
Exactly.
And that's what we're interested in.
Yeah.
Not the fact that some fellow sitting in a committee said, oh, it'll need careful wording.
No, my lord, I fully accept that, but it rather feeds into the point that I've made earlier, which is they're doing the wording pretty carefully. They're looking at the different formulations that could be used.
Yeah.
It's the contrast between 6.1b and 8 on the one hand and 9.3 on the other. And then look at paragraph 1. Terms needed further clarification, and one of the things that needed further clarification was matters related to the protection of the environment. Because you see that broad formulation that had been put originally in Article 6, matters related to the protection of the environment. So a very broad form of words that was used. Go forward to page 531. I think it may be in the next tab. Tab 28, 7th of July 1997, as you see on the top of page 531. This is the 5th section. And then if you go into Annex 3, which starts on page 533, that's a report of the informal meeting on what was then the access to justice provision. And 1C is the one, can I ask you to look at that? It may be that 1C provides a little indication, I hope, along the lines of the answer I gave my Lord Justice Holgate in in relation to the without prejudice wording. Do you remember the
I do.
debate we had about that? Maybe it helps, maybe it doesn't, 1C. But if you look at paragraph 5 on page 534, you'll see the nature of the debate.
So which paragraph?
Paragraph 5 on page 534.
Yeah.
So you'll see that there was a debate about whether or not you needed access to justice provisions beyond the review mechanisms that are referred to, in effect beyond 9.1 and 9.2, see what I mean? Because you can see the two that they were referring to in paragraph 5 from paragraph 1, if you just cast your eye back to those as you read. Other delegations, however, with the opinion it would be appropriate for the Convention to include other provisions on access to justice beyond those, was suggested by some delegations that such provisions could include a right for NGOs to challenge unlawful acts or omissions by private persons or public authorities which contravene specific provisions of national environmental law. So this is really the move from the entirely general impact type wording they had before to something more contained, which contravenes specific provisions of national environmental law. And then what became, in effect, 9.3 is formulated in Annex 5, Option 1 on page 536, where you'll see under Option 1, Sub 3, what became 9.3 effectively, wording which is pretty much materially identical to what 9.3 eventually became. Challenging acts or omissions by public authorities which contravene provisions of its national environmental law.
But is there anything which helps us at all on the approach to relating to?
My lord, there isn't in terms here. It's really the move between
I see that.
the broader provision and the focus on national law, but there isn't.
The question how strong or weak is relating to.
That's true, and there isn't anything in these Travo which assists on that particular question.
Sounds like a compromise.
Maybe it was, but there was certainly a tightening, as it were, away from impact into a focus on the provisions of the national environmental law. And then to cut a long story short, the French provision, which did not change between then and now, effectively reflected that
Are you looking at 537?
no, my lord, sorry, I've just got to find
542, is it?
I've just got to find the French version.
Option 1 in French, 542.
542, is it? Thank you. Yeah, I'm so sorry. Yeah, exactly. 542, option 1 at 3, pour contester les actes ou omissions de personnes privées ou autorités publiques allant à l'encontre des dispositions du droit national de l'environnement.
Speaking entirely for myself, it doesn't get any better or worse in French.
No, but it is the same.
Well, that's encouraging.
Yeah, it is, but it reflects.
I'm not being flippant. At the moment, I don't understand the benefit of these.
Well, my lord, it may become clear, because I think my learned friend is making a point about French and Russian and all the rest of it. And my short point is that the French version, the translation of the option which effectively became Article 9.3 that one sees at 536, the French version is in material identical terms, and that is then reflected when one gets into 9.3 in all the versions.
Page 537 tells us this is a translation from the English. So all we're looking at is how good the translation was.
Well,
it's not taking it any further.
Well, but I'm not going to press the point. I mean, it is. I respectfully submit there is no distinction.
It's the same. Yeah.
The different languages.
It's a good translation.
Yeah. Let's sorry, I'm running a bit over, but can I turn to the 2018 Act?
Yeah. So are we, is this,
That's the end of the general submissions.
right, so
That
that
was
was now
Trevor.
going to the 2018.
2018 Act.
Yeah.
There's no challenge to the judges finding that the purpose of Part 1 is, in our Act, is not to protect or regulate the environment. See the judgment at paragraph 12. The core provisions of the 2018 Act are set out at paras 11 to 14 of our skeleton. I wanted to pick up one argument as the first argument, which is mounted by WWF and may or may not be mounted by the respondents. The WWF says that any challenge to the compatibility of an act or omission with any national law which relates to or might affect the environment in some way is enough. And it submits that Part 1 of the 2018 Act is national law relating to the environment because it has, quote, the potential to produce an environmental impact. That's paragraph 25 of their intervention. And it appears, therefore, to be based on the idea that setting and varying rates of import duty and so on may have some effect on economic activity. That activity may affect other matters and may lead to higher, for example, GHG emissions and so impact on climate change. We make 3 submissions in response. Firstly, if that was truly the intention, it's a strange intention, given the language of 9.3, it effectively recasts Article 9.3. As you'll recall, refers to contraventions of provisions of national law relating to the environment, not national law which relates to or might significantly affect the environment in some way. And as already noted, if they wanted to do it on the basis of impact in that way, they had the ready tools, see Article 6.1b and Article 8. But secondly, it's inconsistent, we submit, with authority, which requires a focus on the nature of the provision said to be contravened, not the mere impact of the legislative scheme on the environment more generally. See for that purpose, and again I don't invite you to turn it up now, but see for that purpose Mr. Justice Eyre in Lewis at paragraphs 31 to 32, tab 16, page 355 to 356. And thirdly, I've already made, but I repeat in answer to this submission by WWF, the submissions I made earlier about purpose from the language and the evident intention to place some limits on Article 9.3. This argument by WWF would give 9.3 an almost unlimited scope, and that would be a very surprising intention to impute to the parties.
Well, if you take this WWF submission to its logical conclusion, if it affects economic activity and that may affect the environment, it's hard to think of a statute that wouldn't be covered by it. Mm-hmm. So you say, even if essentially your core submissions are wrong, this can't be right, because this just goes too far.
Yes, I do. Yeah. They place some reliance for this purpose on the Compliance Committee, and in particular the decision of the Compliance Committee in Austria, the Austrian case at paragraph 52. Again, I don't invite you to turn it up. At page 573 behind tab 36 is where you find that. But that case was different for obvious reasons. It concerned laws on the protection of wildlife species and or trade in endangered species. And their objective was, at least in part, to protect components of biodiversity. So the law itself had a self-evident environmental purpose in the broad sense. But to the extent that it does, if it does, go further and suggest environmental impact itself is enough, that is wrong, we submit. And it's common ground that decisions of that committee are not binding. You'll recall, or you may not recall, it might just be worth showing you briefly Article 15 of the Convention itself, that's Aarhus itself, because that indicates the basis on which the committee is operating. just to show you the status and nature of that body.
Article 15.
Page 513 behind tab 24. This is the provision that led to the establishment of that committee. The meeting of the parties shall establish on a consensus basis optional arrangements for a non-confrontational, non-judicial, consultative nature for reviewing compliance with the provisions of this convention. So that's the basis. By contrast, one might note there's the usual settlement of disputes about the meaning of the treaty itself in Article 16.
Non-confrontational, non-judicial and consultative. It doesn't sound much fun.
No. No. But in any event, that's the nature of the committee. And no doubt it's unsurprising, therefore, that everyone agrees they're not binding. They're certainly not binding, not least because the, as I understand it, the position is that that was a case involving Austria, so it couldn't bind us anyway, even as to the result of the committee's ruling. But the decisions are sometimes adopted by the meeting of the parties, but not the reasoning. So they adopt the result, as it were, against the country, but not the reasoning. And again, it's really to meet a WWF submission that these bodies' views should be given, quote, great weight, as WWF put it. We respectfully submit that that is not the right approach, that they're no doubt entitled to be considered by our courts, but no more really than that. And again, I probably haven't got time to take you to it, but there is a decision of the Supreme Court in AB and the Secretary of State for Justice, Lord Reed giving the judgment, which considers the weight that should be given by domestic courts to various international committees of a similar kind, perhaps not a terribly similar kind given the content of Article 15, but at least there's some parallel there, and urging some caution on the domestic courts before placing too much weight on those decisions. Can I just give you the reference? It's AB and the Secretary of State for Justice, paras 64 to 67. And this one is in, I'm afraid, the WWF intervention file.
Right.
Tab 6, page 347 should get you to those paragraphs.
347?
347 in the WWF file. That case is normally cited for the approach a domestic court should take when considering controversial extensions to the ECHR, the fully confident argument, all of that, ULA and all of that. But it also has a section on the weight that should be given to international committees of this kind, so it's maybe of some assistance there. That's the first argument by WWF, query whether it's being made by the respondents. The second argument, the effect of Section 28, will of course be an issue for argument at the substantive hearing of the respondent's underlying claim. And we, as you know, deny that Section 28 required the UNFCCC matter to be taken into account when making the regulations in question. But we've conceded for the purpose of this appeal only, and in the light of the permission decision, that it plays in, as it were, to the debate that we have today. And my submission in a nutshell is, in response to the way in which the respondents put the argument, is that this is simply too tangential on the relative scale, a connection to fall within Article 9.3. Firstly, it is unclear precisely what the scope of the reference in Section 28 is to taking into account international arrangements. That's the wording that's used. It appears on any view to be directed, centrally at least, at international trade conventions, and one gets that from the explanatory notes, inter alia, at paragraph 130, Authorities, tab 7, page 67, where the only example given is, unsurprisingly, of WTO, World Trade Organization agreements. And you get it also from the very helpful analysis of Mrs. Justice Cockerill in Western Sahara, which my learned friend and I were engaged in. And that is in the Authorities bundle, tab 18, page 390, Western Sahara, and the relevant page 390.
Thank you.
And the relevant paragraphs in her judgment are paragraphs 146 to 150. Again, can I just invite you to note that at that stage? So she effectively concludes that this is really just in the way of a sweep-up provision to make sure that regulations as made don't cut across provisions, as it were, of competing trade agreements. Secondly, and following on from that, sorry,
depending on the facts of the case, I can readily understand where that is all that you would think about with certain sorts of decisions made under Section 28. But if you've got a decision which is going to have an effect on the environment, what is the basis for limiting or excluding reference to international agreements or arrangements that are relevant to that?
It is to maintain the proper limits on the reach of the concepts in 9.3 is the answer to that. And it goes back to the submissions I made earlier. Is it effectively unlimited? Does it apply whenever you are required to think about, take into account, whether under public law or under the relevant provision of a generally expressed statute like that? Does it apply whenever? And my submission is that it doesn't. Section 28 does not have an environmental purpose in that relevant sense. It isn't in nature a part of the panoply of protection, even if, in the particular case, it did require the relevant UNFCC to be taken into account.
And your answer would be the same whether we were talking about Australian beef or Mozambican gas?
It would. It would. It would, because one can see the connection between the two. The public law principle is in essence similar.
Quite.
And that, I respectfully submit, opens the door too broadly. You look at the nature of it.
Well, I know that's your submission. I'm just trying to understand, because we've got to try and put into a judgment something which enables people to know which side of the line they are.
Yes.
And it's one thing to say it's too broad. It's another thing to explain why it's too broad if, on the face of things, international, an agreement to which Section 28 applies, clearly, assuming it does, clearly affects the environment.
Well, I think the short answer to that is it's the difference between a legislative regime, say, that is designed like the planning laws, albeit including the policies per them, that is designed as part of that panoply of protection. It's the difference between that and an international agreement that may have something to do with the environment, falling potentially to be taken into account as relevant.
You're simply going back to purpose.
As relevant. I'm going back to purpose and nature.
Purpose and nature. This is about simply what tariff is going to be paid.
It's about tax, and in certain circumstances, it may well be relevant, just as it is under public law, to take into account international agreements, whether through a generally expressed provision or a deliberately expressed provision that introduces it specifically because you've listed the international conventions in a schedule, or because, as a matter of public law, you take it into account because you considered it in terms, a la Mozambique. I respectfully submit that the fact that it may be relevant to the decision is not sufficient by way of connection.
Because this is going to get more difficult, though, when we go back to the example I gave of the Infrastructure Act, which is primarily concerned with funding for the road network, but explicitly says you've got to consider the effect on the environment.
That is, I agree.
So what happens if a strategy is promulgated, laid before Parliament, whatever, and no consideration at all is given to the effect on the environment? And that's the nature of the challenge.
Well, my lord, again, as I said in answer to you before, you have to look at those provisions.
Because the purpose is to deal with the funding of the road network, but qualified by that statutory requirement to look at the effect. So you might say, well, that's the primary purpose, is the first matter. But
there's a secondary purpose as well.
There's another purpose as well.
My lord, you might do in the circumstances of the individual case, because roads and emissions and all the rest of it. My lord said in relation to the Deutsche case, well, that's pretty obvious because it's to do with catalytic converters or whatever it may be.
Yeah.
And it may be thought that in the context of the sort of example you give about road infrastructure, albeit, and I entirely accept that you can push that one stage further out from the shore by saying it's funding of that. It isn't the implementation of that. But one might say that that is a context and a statutory provision that is closer to the basic environmental purposes and more obviously within that ilk in its nature and purpose as a statutory regime. But it doesn't follow from that, is really the wedge I'm trying to drive between, for the purpose of this distinction, it doesn't follow from that that every time you are required, whether by public law or by statute, to take into account as relevant or potentially or slash arguably relevant to a decision something which might be described as environmental, or you choose to do so that you open up the door to saying you've misdone it under all that debate we had in Mozambique, that it automatically then becomes an Aarhus claim. You still have to focus on the nature of the law, and I fully accept that the example my Lord has now put to me repeatedly, and I'm sure I'm making a hash of answering, but that provision is at the sharp end, and of course one can see that, but my answer remains the same. You have to focus on the provision of national law, its proper structure, and its degree of relation to the scheme of environmental protection that national law has set up.
Do we have any information in the papers? A reference would do, and it doesn't have to be now, to the scope of the FTA, because everybody's thinking beef, 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 and that's why we're here.
It covers more than beef.
Covered a bit more than beef, and that may illuminate your submission, or indeed your learned friend submission, about what the scope and purpose of this particular provision is.
My Lord, it may do, and it may be that one doesn't need, for the purpose of the principled argument that we're debating, one doesn't need to have too much detail on the nature of that agreement. I think I'm right in saying, I'll be shouted out if I'm wrong, but the FTA itself covers a broader range of matters, unsurprisingly.
Certainly beef and the environment is sufficient to be given 15 pages in the impact assessment. But that doesn't tell us all we need to know.
It doesn't tell you all you need to know. It just tells you that it was treated as relevant for present purposes. No doubt, as here, because an NGO had raised the matter, a bit, I suspect, as they did in Mozambique, although I can't recall, and said you need to think about these things jolly carefully because this is going to create an awful CHG or GCG, GHG problem, or here emissions problem, and so the Minister responsibly does that. But again, I'm very, very conscious that it's a not terribly clean-lined, principled answer to my Lord Justice Holgate's question, which is, well, how on earth do we do this, and why, if it's said in terms, take it into account, would that not be part of the environmental scheme?
And I know you're tight on time, but so please don't feel the need to answer it now more. But if there were references in the papers,
I will give you
that illuminate or illustrate the scope of the FTA.
I'll make sure we have them over the short adjournment so you can have them.
I think.
And so the position is that you've got a range, effectively, and you can see the range from the case law, because take the FCA example, well, that's on the other side of the fence. It's a judgment on a spectrum, as it were. You may have a situation like then, where the whole system of planning law is in effect treated as the mechanism or a critical mechanism by which the state seeks to protect the environment, and therefore the whole lot falls in. You may have a situation in which the actual provision of the legislative scheme has nothing to do with that and doesn't have that purpose and isn't in nature of that kind. That is Section 87A in Client Earth and the FCA. And it's also, para 12 of the judgment below, our situation. And that's much more difficult because that does raise sharply what the position is in circumstances where, although that scheme has nothing to do with protection of the environment itself, there may be certain circumstances in which a more or less limited way, which I know is why my Lord is interested in the nature of the FTA, in a more or less limited way, an environmental matter becomes a relevant consideration for the decision maker. And my submission is that that feature whether it is derived from statute or from public law, is not sufficient of itself. Of course, public law is national law. We don't need anyone to tell me that. And of course, legislation is national law. The question is as to its character. And even applying a broad meaning to relating to, my submission is that mere relevance of an environmental matter to the decision in question, whether statutory or created by common law in the variety of ways we've already discussed, is not sufficient. And you need to focus primarily on the nature of the provision that you're dealing with. And my lord, that is my answer to the section 28 claim as put for present purposes by the respondents. And it is also at the heart of my answer to the other way in which it is put, which is that public law, in effect, if it renders relevant an environmental matter, will create an Aarhus claim. That I respectfully submit is far too broad. And I acknowledge, it's the last thing I'll deal with now, but I acknowledge that in making that submission, I am taking issue with, and I do invite you to say was wrongly decided, the decision of Mrs. Justice Thornton in Friends of the Earth, indeed in the Mozambique case itself, on this issue.
Quintessential Aarhus claim.
I'm sorry?
Quintessential Aarhus claim.
That's what she said. But again, one can understand in a way why she says that, because the whole essence of the case was it has a significant, let's use those words, it has a significant environmental impact, or it may do. And
of course, at that stage, she didn't have the material which we had when we came to this, which was that the scheme was going to go ahead
anyway.
In any event, which certainly weighed with me heavily.
Yes, my lord, that's true, but I respectfully submit that the reasoning is wrong anyway, because she got to quintessential environmental claim by saying, here we are, ECGD and or Secretaries of State who were involved in the decision making, I think it was principally Treasury, chose to take it into account in response to a responsible invitation made, responsibly reacted to by Friends of the Earth to take it into account. Having done so, that opened up the debate that the court ultimately ruled on at the substantive hearing, as you will recall, it went to the Court of Appeal ultimately about tenability and all of that. And it opened up the debate about whether there'd been a correct appreciation of the relevant underlying materials when judged against the standard of those international standards. So there was no doubt that environmental matters were swirling around at the heart of the case. That isn't the question for present purposes and is not sufficient, I submit, for the purposes of Article 9.3 of the amendment. So, my lords, that's what we say in relation to the Friends of the Earth decision. If you want that in the raw, it's in tab 15, page 297. And the relevant key paragraphs indicating that the defendants chose to take into account the environmental decision considerations. Paragraph 11, accepting that the 1991 Act didn't relate to environmental protection, but said that because of those public law effects, it was paradigmatically an environmental case. But that's where you find her decision. But the logic of my submission is, I accept and assert that decision was wrong.
Could you just give the page number again, please?
Oh, I'm so sorry. Yes, it's behind tab 15. The key paragraphs start at round about paragraph 11 on page 298.
Thank you.
And that was an extempore judgment, and it's about, I think it's paragraphs 9 to 14 or 15 are the reasoning, and so and it's not entirely clear what material she had, although she clearly didn't have the material that was subsequently available, all the material that was subsequently available to the divisional court.
Yeah. So it might need to be treated with a
question
little
mark whether there would have been a hearing if she'd reached a different view about the Aarhus claim. But whatever the judge at first instance in any given case decides about whether or not a particular claim is or is not an Aarhus Convention claim, I think, certainly speaking for myself, I would be anxious not to encourage appeals. Because these cases are, if this is all about limiting cost, you're not limiting cost if you're encouraging appeal by somebody who doesn't get the protection but wants it, or the party who finds that the claimant has got protection. So that, as my Lord says, we've got to try and identify a clear approach so as to head off at the pass appeals on on decisions which the judge has to make early on, sometimes only on the papers.
On the basis of limited material.
On the basis of limited material.
Well, I entirely accept that. Of course, I suspect that the usual process will apply when you are dealing with tests which are inevitably context-specific and to some extent relative. The judicial approach tends to be not to blank appeals entirely, but take some, if necessary, for the purpose of elucidating precisely how the lines of principle, which inevitably are going to be broadly expressed, might apply, and then clarity emerges, as it were, from a relatively small, hopefully, succession of cases that the appellate courts have offered their views on. And the final thing I want to say... Sorry.
On Friends of the Earth, at page 298, you draw attention to paragraph 11 of the judgment. What the judge seems to have done in that paragraph, not perhaps in 14 where she refers to the Paris Agreement, is she draws an analogy with Venn. And towards the end of paragraph 11, she seems to be referring to policy requirements to assess environmental impact. So she seems to be saying these are policy requirements within a statutory framework.
Well, my lord, yes, I can't quite remember whether there was indeed a policy requirement.
Well, I'm just looking at the last...
of the last sentence of paragraph 11.
Asking perhaps the court to overrule a decision if the reason is not clear.
Well, certainly, I think by the end of the administrative court hearing,
The policy was found not to apply.
It was policy that is not a statutory obligation.
Yes.
I think I can even give you the paragraph number if I try hard enough, but it's
Yes.
not of sufficient interest.
But my lord, again, the submission would be the same here, which is that if you look at Venn, for example, and the parallel is not exact, and it is not a true
There was
analogy.
a statutory requirement to take the policy into account.
And it was part and parcel of the planning context, the two-stage analysis my Lord Justice Stuart-Smith was putting to me. So it's not an exact analogy anyway. Well, I've very helpfully been provided with a note that says the overall scope of the FTA, the best summary of it, an executive summary to the impact assessment, is in supplemental bundle, tab 7, page 97, if that reference helps.
My tab 7 ends at page 93. In the main supplementary bundle.
Oh, sorry, it's behind tab 8. I'm so sorry.
Tab 8, yeah.
Yeah. That is
Which is the impact assessment of the free trade agreement.
exactly. That starts at 94,
Yeah.
which is the best bit of the executive summary. Yeah. It's really that page under executive summary which sets out the bits and pieces, and then you get to the agreement. And it shows you what the agreement covers.
Thank you.
In the various bullets. And it's right to note that the regulations that we're concerned with only implemented the tariff part of this. There were lots of other bits and pieces of the agreement that were implemented in a different form in different parts of the regulations. I'm sorry, I've gone a little bit beyond what I said I was going to do, so apologies to my learned friend for
Well,
that.
we've asked you a lot of questions, and there's plenty of time from Miss Wakefield to take precisely the same amount of time as you, should she want to.
Could I ask, forgive me, you referred to Mr Justice Ayres' decision, tab 17, the Lewis case against the Welsh ministers.
Yeah.
But the proposition, the focus is on the nature of the provision. It's page 355 of the bundle.
Yeah.
31. He goes a bit further than that. It's on the nature of the provision said to have been contravened. And then he says, not on the nature of the act or omission, which is said to have constituted the contravention. I'm not sure where he gets that from, but are you going that far? Your proposition was just the first part of that sentence. It's 31 on 345.
Yes.
It's about 4 lines down.
My Lord, I think I did go that far, and I do support that second part as well, because the provisions of 9.3 require that the state party shall ensure that there is access to administrative and judicial procedures to challenge acts or omissions by public authorities. So obviously that's part of it.
Yes.
Which contravene provisions of its national law. So it is the central focus under 9.3. Of course, it refers to acts or omissions, but those are the
part
things.
of the contravention. I just, for my part, find that sentence difficult to follow. I understand your submission on the first half, but, and I'm not sure where he got it from, unless that's his reading of the...
Well, I think he gets it from 9.3 and its focus on the contravention.
There's no other authority.
No, but it's on the wording that says the act or omission has to be alleged to contravene, and then what has to be contravened, it's national law. I think the point, in fairness to him, he may be driving at, you don't just say there's an act or omission or there's a decision which has an environmental flavour.
It may be a provision you have to read as a whole.
It is certainly a provision you'd have to read as a whole, but having read it as a whole, it's the act or omission is the subject of the challenge, and the nature of the challenge is the contravention of national law relating to the environment. I suspect that's what he's driving at. So,
okay.
I mean, if what he's truly driving at is, it's not enough if you can say the act or omission was environmental or had an environmental context, and I strongly agree with that.
Yes, I understand that.
But that's all.
Okay,
Maybe it may be rather too loosely expressed.
Thank you very much, James. Yes, Miss Wakefield.
May it please the court. The structure of my submission today will be, as Sir James did, I'm going to start with the Vienna Convention and the Law of Treaties. Of course, I'm not going to go over the same territory that Sir James did, but I may need to revisit some of the materials and make different submissions. I'll then run through 6 particular points, which I say can be taken from domestic authorities and are germane to the issues before the court. And then thirdly and finally, I'll get to the proper characterisation of the grounds of challenge in this claim. I'm going to focus, of course, on the Section 28 point, but in order to, I hope, give some assistance to your Lordship, should you wish to go broader, as my Lord indicated, and set out what exactly the position is more widely, I'll consider not only a statutory obligation, as we have in this case, to consider the environment, but also a policy, and your Lordship's discussed with Sir James different kinds of policies. There is, of course, a policy in this case as well. I'll discuss mandatory considerations. So what I'm thinking of there is fewings category 1 and fewings category 3, where they're so obviously material, it would be irrational not to consider them. And then finally, I'll come to fewings category 3. It would be rational not to take them into account. So we have the different layers of the onion, if I can put it that way. And on occasion, with no disrespect at all to my learned friend, one dotted around between those different layers of the onion in answering your Lordship's questions. And although I say all layers can fall within Aarhus, it's plainly the case that the link becomes lesser as one moves out. So I think that may be a helpful way of working through the position when we get there in due course. So if I start with the Vienna Convention, you were taken by my learned friend to Articles 31 and 32. I don't need to go there again. Of course, the 31.1 exercise, objective, context and wording, we know is a single combined operation, taking all three of those elements into account. We also know under 31 sub 3 sub B, the one takes into account subsequent practice. And I will be saying that the implementation guide and the compliance committee falls into that limb. In Article 32, Sir James took you there, supplementary means of interpretation, used to confirm the meaning that we get from Article 31, and then of course Article 33, different language versions. Starting then with one of the triumvirate of Article 31 sub 1, object or purpose of Aarhus Convention. Now, Sir James covered this already in some detail, but essentially one starts with Article 1 of Aarhus. It may be helpful perhaps to open that up again. It's at page 497 of the authorities bundle. And of course, Article 1 has the heading objective, and it sets out what the objective is. In order to contribute to the protection of the right of every person of present and future generations to live in an environment adequate to his or her health and well-being, each party shall guarantee rights of access, and in this case, access to justice, in environmental matters in accordance with the provision of this convention. And in fairness to Sir James, throughout the course of his submissions, he repeatedly accepted or put forward the case with which we'd agree that the purpose of the Aarhus Convention is, of course, effective environmental protection. It is pro-protection of the environment. It is, if I could put it this way, anti-climate change. It is pro-participation of the public in not only other aspects of information, but also access to justice. So that's absolutely clear and I think is accepted. We went to Brown Bear via then, and of course Brown Bear makes the point in paragraph 46. This is the sole point which I think my Lord Holgate said he found of assistance in Brown Bear, that the intention of the Aarhus Convention is to ensure effective environmental protection. That's Article 9.3 in particular. And then as well, of course, we have that broad meaning that one finds as part of the Aarhus Convention to be given to the notion of environment. And your lordships know this already, but one takes that normally from Article 2, the broad meaning of environment in Article 2, and one inserts that same meaning into the word environment.
Well, there was a point here I meant to ask Sir James, that if you go to Article 2.3 and the definition of environmental information, it was accepted there by the Secretary of State that there were two parts of the definition that could be relied upon. One was A, the state of elements of the environment, which in that case was land, but it was combined also with B, factors such as, and in that case it was administrative measures. I think it was there was a misreference in the judgment. They used another word instead of measures, but that's what was being referred to. So it's a combination of A and B. But if you read on in B, you've got legislation, plans and programs, etc., affecting or likely to affect the elements of the environment.
Absolutely.
And one of the elements of the environment is the atmosphere in A.
Yes, absolutely. And of course in B as well, we also have policies before the word legislation.
Yes. Well, you read it as a whole.
One reads it as a whole, absolutely, absolutely, my lord. So we have this very expansive approach, not only to the subject matter, what is the environment, but to the measures that could be taken by one of the contracting states which may affect the environment. And I say that is a very strong interpretative driver when one comes to national laws relating to the environment. One takes a broad approach to those concepts. Further references, Lewis, the judgment of Mr. Justice Eyre that we just looked at, paragraph 6 and 24, he goes to the objective, and he uses that to inform environmental matters having a broad meaning. The RSPB case in the bundle, paragraph 19, we don't need to go there, Mr. Justice Dove, again held that the requirement that claims not be prohibitively expensive arises from the public interest in the protection of the environment. and the need for the public to play an active role in that protection. We have these strong factors in favour of a looser link when one comes to the difficult word related to, in keeping with the broad approach taken in general. That's supported in my submission by context. So the second of our 3 Article 31 sub 1 factors. We know that context includes the preamble. We've got the recitals at page 495 in particular. So starting with the first affirming, that's 5 or 6 down, affirming the need to protect, preserve and improve the state of the environment and to ensure sustainable and environmentally sound development, recognising that adequate protection of the environment is essential to human well-being, the enjoyment of basic human rights, including the right to life itself, recognising also that every person has the right to live in an environment adequate to his or her health and well-being, and the duty, both individually and in association with others, to protect and improve the environment for the benefit of present and future generations, considering that to be able to assert this right and observe this duty, so that, of course, my lords, is a reference back to the recital I've just read, right to live in a good environment, duty to take action individually or collectively to preserve the environment, citizens must have access to information, be entitled to participate in decision-making, and have access to justice in environmental matters, acknowledging in that regard that citizens may need assistance in order to exercise their rights. So in my submission, those are the parts of the preamble that are of particular assistance to the issues before this court today. The words themselves, before I turn to the words themselves, other parts of Aarhus that were raised today by Sir James. So we spoke about the savings provision in Article 3.5, which essentially says you can go further. But I say, to use the language of Mrs. Justice Cockrell, that's nothing more than good housekeeping. One has an international treaty, and one needs to know, does it fully occupy the field? Does it exhaust the position such that contracting parties can go no further? Or is it possible to go further? Well, it's possible to go further. What could one do? Let's not forget that 5.3 refers to all of access to justice, so all of the parts of Article 9. Well, there are numerous ways one could go further. One could say, for example, just thinking about 9.4, rather than not be prohibitively expensive, one could decide, well, it will be a no-cost jurisdiction. It's not expensive at all. There are lots of things different member states could do, or contracting states could do, to exercise their ability to go further than the position in Article 9. But what one can't take from that standard provision, which says we aren't fully occupying the field, is what I think Sir James was seeking to draw from it, namely that Article 9 must therefore have some kind of restrictive interpretation. That's wrong in my submission. That's far too much weight upon that provision. And finally, of course, the other reference which I'd like to pick up is the Article 6 reference to significant environmental impact. And of course, the point that was made by my Lord Justice Holgate, I think, in relation to what one has already in the annex to Aarhus, by way of context, the context bit of my submission there. In the annex to Aarhus, one has listed, as one of the presumptively significant things, industrialised meat production. It's there already.
Say it again. In the annex, you have...
In the annex, one has industrialised meat production. So one has that... I think I'm using the language of my Lord Justice Holgate.
My language wasn't as elegant as that.
I'm sure that's not true. So it's page 521, 19, other activities. A, slaughterhouses with a carcass production capacity greater than 50 tonnes per day. B, treatment and processing intended for the production of food products from animal raw materials other than milk, with a finished product production capacity greater than 75
In fact, what I had in mind was 15 intensive livestock rearing.
I'm sorry, you've done far better than I did.
But that, I mean, it happens to mention poultry and pigs and so on. But...
It does, and not cows. But what one sees there, essentially, is when one's thinking about the subject matter of my claim, I'm squarely within what the drafters of Aarhus were considering when they were thinking about connection with environmental matters, in that looser contextual sense. I don't say, I'm going to come on to 9.3 and how 9.3 works, I don't say that answers the question, but when one's taking into account context, the sorts of things, beef, 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 those sorts of things are in scope of this convention. So there we are, that's context. The words themselves, we obviously say that the use of the word related to, or the words related to, is critical.
We're now going to 9.3.
I'm in 9.3.
Yeah.
I'm in 9.3. So I'm still in the exercise of Article 31.1 of the Vienna Convention. And I've thought about objective and context. And the third limb is the language used itself. And that's the language of Article 9.3.
Mm-hmm.
And I say that the language of related to is obviously critical because it imposes a degree of distance between the national law and the environment. It's different from using national environmental laws. And I'll come on to the implementation guide, which we've already looked at, but also the decisions of the Compliance Committee, which support me in that and confirm the importance of that language. In terms of different language versions, I should say both the different language versions point and the Travo point were originally my learned friends points, which I'm responding to, but in any event, the different language point, which is Article 22 of the Aarhus Convention, you'll recall my learned friend referred to it earlier, that provides that there are 3 authentic versions of Aarhus. So this isn't a Travo point, it's an authentic treaty version point. The English uses the words with which we're familiar, related to. My learned friend in his skeleton argument makes the point that the French version uses different language, and it's language that would be the equivalent of national environmental laws. It omits the word related to. So he makes that point in his skeleton argument. To which I responded, and put my learned friend and his team on notice earlier this week, well, if you go to the Russian version, that uses the same language as the English version. The Russian version has related to in it. And I attached to that email a screenshot of the Russian version, and I'm ashamed to say Google Translate was sent it on Wednesday night, I think. So we have 3 authentic versions. 2 of them have the language related to, and 1 doesn't. What we do when there's that kind of difference is set out in Article 33. So we're in tab 22 of the authorities bundle, looking at the Vienna Convention. Article 33 is on page 485. In a sense, it's unsurprising. So when the different languages are authentic, they're each equally authoritative. In Article 33, sub 3, the terms of the treaty are presumed to have the same meaning in each text. And then in 4, except when you've got who wins mechanism, and when the comparison of the text discloses a difference in meaning, which you can't remove through 31 and 32, the meaning which best reconciles the text, having regard to object and purpose of the treaty, should be adopted. So I say, first of all, applying 31 and 32, one can get to the position where one treats related to as a component part of the treaty, read across all of its language types. But even if one couldn't, the version which best reconciles the texts is the version that has related to it. It's in 2 of the 3, and one sees that it is referred to in the implementation guide, and the choice of related to is treated as particularly significant by the Compliance Committee.
Well, that's been the basis of the submissions we've had today.
It has, exactly.
So I don't think there's anything between you on that. Interesting, though, Article 33 of the Vienna Convention may be to some.
I'm sorry.
No, that's right.
I'll move on. But that's the point about language versions, and the point to which my learned friend made some reference. The implementation guide. I've been there already, so I can take this relatively shortly, I hope. Tab 39. Page 609. You have that photo of the person addressing the committee. when we've looked at this already, but
I hadn't looked at it before today on page 609, but it's cited, one of you at least, quotes it.
yes, absolutely. It's in our skeleton argument.
Thank you.
It is.
I thought it looked familiar.
It looked familiar. That's a good sign. That's a very good sign. So, of course, the part of this paragraph.
I notice, I'm sorry to interrupt you, I notice at 606 there's a disclaimer. The views expressed in the implementation guide do not necessarily reflect those of any individual organisation or government involved at any stage in the preparation of its text. Similarly, the interpretations contained in the text do not necessarily represent the official opinion of any of the parties to the convention.
I'm going to make your heart sink, but if you would like to be addressed on that further, I can draft the shorter German. I asked a similar question before, and I think there's a Riga Convention that says something about it. But the long and the short of it is that reference is frequently made to the implementation guide. You'll have seen that perhaps in Venn, for example.
Yes, as I said to Sir James, I'm still waiting for a case that turns on an implementation guide as opposed to the meaning of the actual
That's an
convention.
Of course, my lord, of course. But so this is an Article 31, sub 3 points for the Vienna Convention. So this is subsequent state practice. It's not travaux.
No, I understand that.
Prior. And so this is, I would say, of more assistance because it shows.
Well, depending on what it says.
Depending on.
Yeah.
I mean, to be told that relating means somehow relating to the environment, it isn't particularly illuminating.
It's not massively illuminating, but I think it shows that the nexus is looser rather than tighter, and somehow relating to.
I think we can get at this from our own jurisprudence. I mean, it's going to turn on context, purpose, and the wording of the legislation.
It is, my lord. I'll move on, but could I just make this point? So, my learned friend focuses on the language environmental taxes here. I don't know if your lordship keeps on coming back to that. But if one reads the entire sentence, it has environmental taxes, and then the end of the sentence is regardless of whether the provisions in question are found in planning laws, taxation laws, or maritime laws. What that means is, if you had a taxation law, like the 2018 Act, and you had a single provision in it, like Section 28, that properly viewed related to an environmental aspect of the tax, one looks at that provision and one doesn't get camouflaged by the nature of the broader Act. It says look at the substance, don't look at the label, and don't look at the general nature of other things with which it is bundled. That's the proper meaning of that sentence. I'll move on, say that I can see my Lord Justice Stuart-Smith may have a question. Do you have a question? No.
No. I'll ask it if I do.
Okay. I'll move on. The Aarhus Convention Compliance Committee. So my learned friend directed your lordships to AB and the Secretary of State for Justice, and also in general, if I might put it this way, sought to downplay the importance of the Compliance Committee. Now, in Austin, Lord Justice Elias, in paragraph 9, page 102, said enforcement of the convention is in the hands. Page 102.
Sorry.
Is in the hands of the Aarhus Convention Compliance Committee, a body of practitioners and academics. Whilst not a court, its decisions deserve respect.
I'm not going to ask a question, but I'm going to make an observation.
Go on.
Which is that I'm having a bit of trouble keeping up with you from time to time.
Sorry, I'll go slower. It's my fault.
Well, it just if you could see that all three of us are struggling to find our place, we could wait. Thank you.
Of course.
You're not under any time pressure from us.
Thank you. That's very helpful.
So, paragraph 9
Paragraph
deserves
9.
respect on issues relating to standards of public participation.
Yes. But the same respect across the board, that he has no different locus in relation to public participation compared to access to justice. And of course, he cites the prior decision of the Court of Appeal in Walton for that. And in my submission, it's absolutely established that one pays respect to the decisions of the Compliance Committee.
Well, that's a Supreme Court decision, Walton.
Sorry, I haven't got it open. It may well be.
Well,
so I apologise for not knowing that. the top of my head. But your Lordship has the point that there's a specific approach that's taken to the Compliance Committee rather than general statements. And of course it's not binding, and of course it's not a court. But their views deserve respect. I put it no higher than that. Two decisions in particular, Austria. Tab 36 of the authorities bundle.
Yeah.
Page 565. So, as my learned friend said, this complaint concerned animal protection, principally trade in wild animals, but also conventional animal protection, if one can put it that way. And the question in issue was, in particular, access to criminal and penal proceedings. That's the backdrop to the case. One sees, just for the general animal protection point, in as much as it's relevant, page 568. Paragraph 22, we have an A, Wildlife Trade Act, B, Nature Conservation Act, C, Conservation Landscape Care Act, and then in D, Animal Protection Act. So that penalises in Austrian law acts that inflict pain, injury or suffering to animals. So that's the context of that complaint. Paragraph 50, which is on page 573. First question is the meaning of national law relating to the environment. And then paragraph 52 is the one to which reference is often made, and reference is made in our skeleton argument. And could I invite your Lordships to read that paragraph?
52.
52.
Yeah.
And so 2 points, of course, from that paragraph. First of all, the importance of the textual decision to have the words relating to rather than national environmental
Don't we get that,
laws.
all of this from our domestic cases?
We do, my lord. We do. I think that is only set out probably in Client Earth, their end words. So if I could ask you to take it
I think
closer.
the submission you just made, if I can put it, if I've got it, is that it's not referring to environmental law. In other words, it doesn't mean a law having to do with the environment. It's law relating to, which then leaves the question: what's the strength of the connection?
It does absolutely, my lord. So what I'm seeking to...
It's not environmental law in the sense of law having to do with the environment.
Absolutely, and so in due course, your lordship has the point, but I'll be saying that Sir James is entirely wrong in his submission, where he repeatedly comes back to this idea it has to be environmental law, it has to be part of environmental law of the UK. Oh, planning's different because planning is all environmental law. That's not the test at all. It's relating to environmental law, and we have those words at the end of paragraph 52, which we do see in Client Earth and perhaps in other authorities as well, relate in general to, or help to protect, or harm, or otherwise impact on the environment. These are loose connections. So that's my submission. And I do say that is a decision to which respect should be accorded, no higher than that.
Why do you say those are loose?
I say they're loose because...
Help to protect or harm or otherwise impact the environment.
So first of all...
There's a connection.
There is a connection. There has to be a connection.
They're related to the environment.
They are, my lord. So first of all...
Speaking for myself, and it may be that I'm betraying my background as a contract lawyer, I don't have any difficulty with relating to. Indeed, the first case I ever did at the bar that was reported was about the meaning of in connection with. So I know about that. I did anyway. I don't have any difficulty with it. All of those things I don't get. I mean, tightness or looseness may be a question of the individual case, but may relate in general to or help to protect or harm or otherwise impact on the environment. Well, that's just an expansion of relating to.
That's very helpful, Will. So if your lordship takes the view that this is already bound up in the proper meaning of the word relating to, I'm of course very content with that end position, and I don't want to confuse matters by contending for broader or narrower. If it's helpful to think of broader or narrower in the context of relating to, I obviously say that looser connection rather than the tighter connection contended for from a learned friend is the right one. And I'm taking your lordships, although I know the process is painful, through these materials because each of them supports me. And Sir James has nothing on his side. And that's the end point I want to get to this afternoon. I heard the clock strike 1, and so I don't know if now would be a good moment.
So gripped am I with this that I didn't hear the fine. Okay, thank you very much. We'll come back at 2, I mean, you've already covered quite a bit of ground. Yeah. Well, we'll come back by 2. So I'm sorry, it's slightly less than an hour.